Right Honourable Vice President, distinguished guests, ladies and gentlemen. It's a great honour to have been asked to speak to you at this conference. This is my first visit to Nepal and to Kathmandu, and I was struck yesterday as we were coming in to land with the beauty of the country surrounding it and the terraced fields which Justice Batara tells me have gone back thousands of years, and also the astonishing scope of the city of Kathmandu. I've come to speak from Australia, but I come to speak with all the humility that one should, speaking from one society to another with very different histories and characters. Australia has a population of about 26.5 million people, and that's spread over more than 7.5 million square kilometres. That makes 3 people per square kilometre. Nepal has over 31 million people, with a total land area of about 143,000 square kilometres, which makes 216 people per square kilometre. When I look at our constitutions, your constitution has 308 sections. Our constitution has 128 sections. So Nepal has 465 square kilometres per section of its constitution. Australia has 60,017 square kilometres per section of its constitution. Ours is 122 years old. Yours is 8 years old. They share the common feature of division of powers between national and subnational components of the country. They have very different histories. They have very different societal contexts and quite different provisions. But despite that, they have the common feature of all federal constitutions. To make them work, cooperation is essential. Cooperative federalism is a challenge in any federation, and I'm not here to suggest that Australia has solved the problem of cooperative federalism. Hearing some of the earlier speakers talk about, for example, financial issues between the federal government and the provinces and the local government, those remarks have a familiar ring in Australia. Our state governments are always complaining about inadequate funding from the Commonwealth government or unfair sharing of the distribution of revenues collected by the Commonwealth government. These are common problems. Our Australian Constitution doesn't actually spell out mechanisms for cooperation between the Commonwealth and the states. Your Constitution, on the other hand, makes extraordinary and express provision in Part 20 for managing relations between federal, provincial and local level governments. The inclusion in your Constitution of those cooperative mechanisms sends a clear message to those who are entrusted with government at federal, provincial and local levels. And that is a message which comes from what your Constitution says is the sovereign authority of the people upon which it is based. But in the end, however good your mechanisms are, and whether you have mechanisms for cooperation or not in your Constitution, cooperative federalism depends upon the people who have to make it work. It depends upon their vision, their good faith, and their ability to put interests of the whole nation above their own political or other interests. There was a great Indian constitutional lawyer, Dr. Ambedkar, who made a remark which I've often quoted on the day before the Indian Constitution came into effect in 1948. He said this, and they of course have, as you know, a complex federal constitution. However good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those who are implementing it are good, it will prove to be good. It is down to the people. Now let me talk briefly about the concept of cooperative federalism generally, and this is something which applies right across federal systems. It describes an attribute of a federation under which its component governments, in your case the federal, the provincial and the local, engage in cooperative action with a view to achieving common objectives. And that kind of cooperation can take various forms. It might be in the making of laws, the making of complementary or common form laws by different levels of government, laws which fit together and operate together. It may be through intergovernmental agreements between different executive governments, and these may make provision for cooperative administrative action. They may also make provision for cooperative lawmaking at different levels. In funding arrangements, so for example, conditional funding may be made available by central government to state or provincial governments under agreements about how they are to be applied. And we have in Australia a very common system of conditional grants made by the Commonwealth to the states, which the states are free to accept or reject and are done under agreements with the states. And of course, in the establishment of mechanisms for regular communication between the different parts of the Federation, such as ministerial councils or councils or groups of senior officers who have similar responsibilities at the different levels of government. Also, cooperation can be vertical between local, provincial and federal governments, or it may be horizontal between provincial governments, between local governments. It may use joint decision-making mechanisms set up with the support of laws made by national and other governments and or executive agreements between them. It may use joint decision-making mechanisms or a single decision-maker set up by one government with a process of consultation with others. Federal government and provincial or state government legislative powers may also be used to set up a national authority for particular purposes, exercising powers conferred on it by laws made by both the federal and the state or provincial governments. These are a number of examples of the way that we've approached cooperative federalism in Australia. One particular example, which I might mention in a little while, is energy regulation and how we deal with that in an area where we have overlapping federal and state responsibilities in electricity markets. Anything I say, of course, about cooperative federalism in Nepal from an Australian perspective must acknowledge that our federal constitutions come out of very different eras and histories. Our federation was born out of negotiation between 6 self-governing colonies on the Australian continent who saw it in their common interests to combine to form one nation. There were no diverse, geographically defined ethnic communities to be accommodated. Diversity was not part of our nation-building agenda, nor was social inclusion. Much, of course, has changed since the Australian Constitution came into existence in 1901. Today, Australia is a multi-ethnic and multicultural society with people from 180 different countries. Nearly half of our population was either born overseas or had one parent born overseas. Our ethnic diversity is a product of immigration, which began to be diversified in the second half of the 20th century. Making allowance for those very different histories and backgrounds, can I make some observations, firstly, about how I understand governmental powers to be distributed in Nepal and compare that with the position in Australia, and then say, despite those differences, there are common approaches which one can take to cooperative federalism which cut across different models of federation. Looking at the Constitution of Nepal, I observed that it defines the main structure of the country as consisting of three levels: the federation, the province, and the local levels. And you have a distribution of powers between those levels, as we have under our Constitution in Australia. And those are all set out in the schedules to the Constitution: the powers of the Federation in Schedule 5, the powers of the provinces in Schedule 6, the concurrent powers of Federation and provinces in Schedule 7, the local level powers in Schedule 8, and the concurrent powers of Federation, province and local levels in Schedule 9. Can I just mention one point of difference between Australia and Nepal in relation to those levels? We have federal and state and local governments in Australia, but the local governments are not set out in our Constitution. They are simply creations of state laws. So they are completely controlled and defined by state law, although sometimes they may receive funding for particular purposes from the Commonwealth. You have a paramountcy provision, that is to say federal law overrides inconsistent provisional or local laws. We have the same sort of thing in Australia in section 109 of our Constitution. And your federation has power on any matter which is not listed in the combined list of things set out in the schedules. I can speak very shortly, by way of comparison, of the Australian Constitution. It establishes the Commonwealth of Australia as the national polity, and the former self-governing colonies became the states of Australia. So they're the equivalent, if you like, of your provinces. We also have a couple of self-governing territories. So where our capital, Canberra, is located, it's called the Australian Capital Territory, and that is given a parliament with lawmaking powers, but that parliament is created by Commonwealth law. And similarly, the Northern Territory, which is a self-governing territory but not a full state. A striking difference between your Constitution and ours is the very strong and express focus in your Constitution on cooperative federalism. There's no real equivalent to this in the Australian Constitution. And here I'm referring to Part 20 of the Constitution of Nepal, which is dedicated to interrelationships between the Federation, the provinces, and the local levels. And I'm struck by the very important principle set out in Article 232, subpara 1, which says the relations between the Federation, provinces, and local levels shall be based on principles of cooperation, coexistence, and coordination. And there follows on from that a number of articles dealing with relations between the provinces, the Federation, and local authority. There are some equivalents to us. You have, for example, a provision in Article 233 that a province shall, in accordance with its provincial law, provide equal security, treatment and facility to the residents of another province. So in other words, there's a sort of non-discrimination principle in your Constitution, so that a resident in one place is not treated differently, at least the residents of a particular province are not treated differently from the residents of another province who come there. We have a similar rule in Australia, that the residents of one state, that a state cannot discriminate against the residents of another state. And we have a state called Queensland, and for many years they tried to protect themselves against lawyers from the southern states by creating a residency condition so that you had to live in Queensland for 6 months before you could practice law there. And that was struck down by the High Court as discriminating against the residents of other states who might want to practice law in Queensland. So that non-discrimination principle was part of a number of provisions of our Australian Constitution dedicated to making Australia one nation and one economic union. And of course there's another provision, a famous provision of our Constitution, section 92, which says that trade and commerce between the states and movement between the states shall be absolutely free, so the states can't set up their own customs barriers. Now, the mechanisms which you've got this remarkable set of mechanisms in your Constitution which are plainly directed to facilitating cooperation between the various levels of government. We don't have those in Australia, but the mechanisms which we have used to try to effect cooperative federalism have come out of the general lawmaking and executive powers of the Commonwealth and the states. You also have statutory provisions of some importance for cooperative federalism in Nepal, which I would want to recognise in this speech. So the Intergovernmental Relations Act is a key example, an act designed to manage coordination and intergovernment relations between federation, province and local levels. And you have a National Coordination Council and a Provincial Coordination Council and an Intergovernmental Fiscal Arrangement Act. It's hard to imagine a clearer scheme for cooperative federalism than in your Constitution and in the laws that have made under it. But in the end, as Dr. Ambedkar said, it's all about the people. You can have all the wonderful mechanisms in the world. It's the people who have to make them work. I want to just mention briefly some of the techniques that we have used in Australia for cooperative federalism consistently with our Constitution, and some of them have already been mentioned in passing. Until recently, our leading political mechanism for the practice of cooperative federalism in Australia was the Council of Australian Governments, and that was set up in 1992. And its members were the Prime Minister, State and Territory Premiers and Chief Ministers and the President of the Australian Local Government Association, so that local government was recognised even though it wasn't a constitutional entity. And that council, during the time that it existed, developed an extensive reform agenda which emphasised cooperative working relationships. For example, an intergovernmental agreement on financial relations, whose object was to enhance collaborative federalism by reducing the previous complexity of the Commonwealth's financial relations with states and territories, to prompt greater flexibility in service delivery and to enhance public accountability for achieving outcomes. And under that agreement, there was a whole set of national agreements, national partnerships, project agreements and implementation plans. 6 national agreements covered service areas of healthcare, education, skills and workforce development, disability, affordable housing and Indigenous reform. Now, one feature of some importance to those who want to understand the Australian Constitution is because the Commonwealth effectively is financially dominant in Australia. It's the main collector of taxes. It is able to enter into fields which aren't actually directly within its area of constitutional power. And it does that through agreements with the states. And those agreements may take various forms. But for example, university education is not part of the constitutional responsibility of the federal government. And yet the federal government is dominant in the area of university education because it is the primary funder of that education through the states and otherwise. What we found was, of course, that this National Council, this Council of Australian Governments, didn't work perfectly. It did not deliver perfect cooperative federalism. And I want to make it absolutely clear that cooperative federalism in Australia is still a work in progress. And politics intersects in. That's inescapable, that politics will play a part in any endeavours at cooperative federalism because there will be interests in tension. In your case, no doubt, the interests of the provinces and the local authorities, and we've heard a little bit of that in some of the speeches which have already been made. There was some criticism of our Council of Australian Governments. We had a National Commission of Audit which pointed out it had generated over 300 documents. And at the time of the COVID pandemic, we actually dismantled the Council of Australian Governments and set up what was called a National Cabinet to try to respond more quickly and effectively in a coordinated way to the effects of the pandemic. There have been a number of particular mechanisms which I'll mention briefly without getting into detail, having regard to the time, which we've used in the area of legal cooperation. So one mechanism is this, and you can track it really through the way we've dealt with the regulation of companies. Back in the 1960s, we had a system of what was called mirror legislation. So each state would pass a Companies Act in the same form as every other state. So every state would have its own Companies Act, but those Companies Act were pretty well identical. But there was nothing to stop the states from actually changing them or tweaking them, so you could get differences come in over a period of time. And then we moved to a different system, where the Commonwealth actually passed a law in the Australian Capital Territory for a Companies Act, and the other states of Australia adopted it, and that was called the Companies Code. So that was a different approach, to try to get a uniform approach to the regulation of companies. And then the Commonwealth tried to go it alone and say, well, we think we've got the power to do this all by ourselves, and they passed the Corporations Act, which swept aside the state acts. But the High Court said, no, you can't go it alone, because although you have power to make laws about corporations, you don't have power to make laws about their formation and their winding up. And so the Commonwealth had to go back to the drawing board. And in the end, what happened was we got a system where the states actually referred the power to make laws about companies, including their formation, to the Commonwealth. And you can do that under our Constitution. And it made a law upon which they were all agreed. But that law, that corporations law, will not be amended without the agreement of the states which referred the power. We have an interesting variation of that with our energy regulation. So with our energy regulation, we have an agreement between the Commonwealth and the states. One of the states passes a law, setting up a national electricity law, for example, and the other states and the Commonwealth actually adopt that law. So you have, again, a uniform law. And between them, they create a national regulator, which has powers from all of the states. So these are some of the approaches that we have taken to trying to get uniformity in important matters. Evidence laws, for example, we have national uniform evidence laws which each state adopts. The legal profession, traditionally regulated by the states, is now regulated under a uniform law which has been agreed between most of the states. In conclusion, cooperative federalism, as appears from our experience and no doubt from other national experiences, is always a work in progress. It's to be expected that developing federations will learn by experience. Some initiatives will be found to be defective or able to be improved in the light of experience. And some, of course, will struggle because of contending political interests, the interests of states and the centre, which tend to have sometimes issues between them. There is one caveat, one caution I would attach to cooperative federalism. It is designed to serve purposes which go well beyond those which can be achieved just by the central government or the provincial governments acting alone. But it does have a tendency to centralise power, despite intergovernmental agreements and supervisory arrangements. Every topic which is treated by agreement as one requiring cooperative action becomes potentially a topic of which it can be said that it is best dealt with at national level. Finally, cooperative federalism is not an end in itself. It is a means to an end. The better exercise of legislative and administrative powers to achieve better national laws and practices than would be achieved if all governments simply went their own way under the Constitution. It's important, of course, to prioritise, decide what are the most important areas in which cooperative mechanisms should be established and implemented. There are no doubt many competing priorities in this area for Nepal, and a desire to explore the ways in which they may best be defined and addressed. It's my pleasure to be at this conference and to be part of that discussion. Thank you.